I did 20 years in prison, 12 years administration segregation. I hadn't been in trouble in 4 years. I wasn't talking to nobody, Your Honor. I respect the judge. My mother was an Air Force pilot. Probation, plea bargain.
I'm going to do a referral to Esperanza Court based upon what I've reviewed in the PSI report. Now, here's the thing. You have issues going on with you. She didn't want to do it. She'd rather just go to prison, and everybody can present whatever evidence they wish to present.
This woman walked into Judge Boyd's courtroom facing a serious situation, a repeat assault charge while already being on probation, with the possibility of significant prison time hanging over her head. But when she entered the hearing, she seemed to believe everything would work out in her favor. Almost like she expected to walk right back out the same day, without any major consequences. Then Judge Boyd started explaining the sentence, and you could see the entire mood change. That confidence disappeared quickly. The reality of the situation finally seemed to sink in, and her reaction said everything. Let me know what you guys think about Judge Boyd's approach here, and let's jump into the hearing.
And are you Miss Morgan?
Yes, ma'am.
All right.
Yes, ma'am, Your Honor.
All right.
I got a little sore throat because the air conditioner over there in my dorm in 2 Bravo is freezing cold, and I'm sorry my voice is a little hoarse. I wasn't talking to nobody, Your Honor. I respect the judge. My mother was an Air Force pilot, 97286, even though I broke the law before her. I apologize.
Oh, your apology is accepted.
It's horrible conditions.
Yeah. All right. So here is my question. Defense. Have you had a chance to confer with her? She said that she was hearing voices or.
I take medication. I take Geodon.
All right. And yes. Do you believe she's currently competent?
I do so believe, Judge. I did speak with Mr. Saldana, and he expressed that his intention to go forward with this plea and Ms. Morgan's intention to go forward.
All right. Ms. Morgan, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, Your Honor.
All right. You can lower your hand. State your name for the record.
My name is Natasha Elizabeth Malloy Morgan, Your Honor.
All right. Ms. Morgan, if you were released, where would you be living?
I was going to go to the Hayden while you was gone on vacation. I seen Judge Hahn, I believe her name is, on May the 17th, Your Honor. And she had asked me the same question that you asked me.
All right. That would probably be Judge Her.
I'm sorry, I knew it was H.
All right. So with regards to your mental health issues, do you have a doctor that you see when you're not in custody?
No, I'm on a roll in I Medicaid Superior and Amcon Insurance. They have Central Meds up there, but they have Center for Health down the street that they have a psychiatrist there that will be available to give me my psychiatric medication. Release if you decide that it's in your favor, in your judgment to release me on the 10 years of probation, plea agreeable bargain. Yes, ma'am.
All right, and state you may be excused.
Thank you, Your Honor.
All right, the court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's a $500 fine that will be probated. She's going to be on the MIC caseload.
Yes, Your Honor.
And that's based upon the evaluation that the court has seen. I'm going to ask for a trauma assessment, and I'm asking for that based upon what's in the PSI report. There's to be restitution, if any, to Jerry, Jeri Brown. I'm going to do a referral to Esperanza Court based upon what I've reviewed in the PSI report.
As this hearing continues, it becomes clear that this case involves more than just the criminal charges. The court is also dealing with serious mental health concerns, and it appears she may not fully understand the severity of the situation in front of her. She seems surprised by the court's decision to consider Esperanza Court, a program designed to help defendants dealing with significant mental health challenges while still holding them accountable. Watching her reaction, you can tell she wasn't expecting this direction, but from the court's perspective, this isn't about punishment alone. It's about finding an option that gives her structure while also protecting the community. The judge has already shown patience, but there comes a point where the court has to decide what happens next if previous opportunities haven't worked at what do you think? Should she receive another chance through a treatment program, or should the court move toward a longer sentence?
If she's not accepted into Esperanza Court, then we will, that'll be the first one. If she's not accepted there, then we'll try felony drug court. The reason why I'm suggesting these, now, here's the thing. You have issues going on with you. I'm reading the PSI report. I've read the PSI report. I've seen your diagnosis. Going to Haven Hope is not the best place for you. You need a place where one, and these programs that I'm recommending to you, they're all outpatient programs, but you are going to be in custody for the weekend. Felony drug court and Esperanza Court, they will send someone over to interview you Monday or Tuesday. And if you're accepted in those programs, you'll probably be released on Wednesday, and you'll be released to be in their program. What I can tell you is Esperanza Court and Felony Drug Court, they'll be able to help you with housing. They'll be able to help you with any mental health issues, and that's what you need. You understand? All right. And they will do it by next week. It will be done. It's not going to be done. Well, there's still a strong possibility they may be able to see you this week, but because of the holiday, it may not be 100% this week, but definitely by the following week. And counsel, if it's not done by Tuesday of next week, just come back in and we'll have it brought over and I'll do something else.
Yes, Your Honor.
But you need to be open and honest with them. You understand? All right. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be proof of employment or SSI within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be 200 hours of community service restitution. I'm going to order anger management. Once that's completed, the community service hours will be deemed satisfied. Probation, is there anything else she needs?
No, Your Honor.
All right. Is there anything else you need from the court to be successful?
I wanted to ask you, am I allowed to speak?
Sure, yes.
I don't understand. I've been in psychiatric care since the age of 9 years old, state of Oklahoma
Mhm.
and in Texas. And I just don't see how psychiatric, I mean, like everybody wants me to take medication, it seems like, for issues. But, you know, I did 20 years in prison, 12 years administration segregation. I hadn't been in trouble in 4 years. And 2 of them imprisonments was on false allegations. And then on this one, I mean,
Well, here's the thing. Let me explain something to you. So with regards to medication, if the doctor says you don't need medication, if the doctor says, she just needs therapy, then that's what we'll do. But what I'm reading in the TAP evaluation, it states that you're on medication at the jail.
yes,
So,
yes, ma'am. I do take the medication in jail issues, but I do know within my rights as the state. I've been to South Shore, Chandler, Florida Ridge. I've been to mental hospitals. Like I said, state of Oklahoma, my mother was military. I was myself in post Oklahoma. If that's court order, I mean, like medication, I don't use drugs or alcohol or anything.
well,
like
this is
that.
what I can tell you. Legally, with medication, if you choose not to take the medication, what's going to end up happening is you may or may not decompensate. If you decompensate and become incompetent, they are probably going to take you into custody because this is considered a violent offense. And then they will seek to help you regain competency. And if they determine that medication is what will make you become competent and you choose not to take it, it will go before a judge. And then when it goes before that judge, they'll have a hearing on whether or not medication is to be forced.
So what do you,
And here's the thing, you'll have an attorney to represent you at that hearing. I'm just giving you these rules and I give people conditions. You have a choice. You can follow them or not follow them. That is completely up to you. And of course, there are consequences when we make certain choices.
Now we move forward about 6 weeks, and the situation has become even more complicated. The judge is now trying to place her into Esperanza Court, which comes with much stricter requirements than the program she originally wanted. And it's clear she's not thrilled about that. These programs aren't just a simple agreement to stay out of trouble. They involve regular court appearances, treatment requirements, testing, and a lot of structure. One mistake can completely change the outcome. Watching her reaction, it almost feels like she's realizing for the first time how serious this has become. The question now is whether she's finally ready to follow the rules, or whether the court is running out of options. Do you think judges should continue offering programs like this? Or is there a point where consequences have to take over?
With regard to the non-enrollment in the Esperanza, Judge, I believe my client was a little bit confused because she was under the impression it needed like to be a prostitution or a drug charge. Now I told her that that's not necessarily the case. If the Esperanza court assesses her and they feel that she does meet criteria, then she would need to do that program. I did speak with the Esperanza court caseworker, Ms. Benavides. She did state that they attempted to do an assessment, however, that was cut short, but that they would not mind doing an assessment now that my client knows more about the program, and to be able to give them a better look as to whether she meets criteria or not, that they can meet with an assessor either tomorrow or Thursday.
Okay, here's the thing. I don't know why I should give her a chance to do that. And this is why I'm saying that. When we were here on July 2nd, here we are in August, I ordered that she was to be assessed by a Esperanza court. I don't know why people think, and I'm speaking in general terms, why people think when I order something, their option is, oh no, I'm not doing that. I don't want to do that. The word I received back from Esperanza court, I believe, is she didn't want to do it. She'd rather just go to prison.
I think it was just be continued to be allowed to do her probation. I know that she was released and checked in and did her orientation.
I wasn't released. Excuse me, Your Honor. Can I please have permission to speak, Your Honor?
Sure, you can speak. You can explain to me why you didn't follow the
That was
court's
July
order.
16th, ma'am. When I seen you July 2nd, I've been over here 11 times. You explained to me that you would grant me the 10-year probation. You asked me where I was going to go. You said you wanted Esperanza. I have the probation papers in my dorm that you wanted me to go to Esperanza Drug Court, Your Honor. On July 16th, I was pulled out. I'm not, like I said, I was Corpus Christi area when I was arrested when I did my 20 years in prison. I'm not aware of the San Antonio Drug Court. Never been to it.
No, but here's the thing.
I did it on July 16th, ma'am. They took me to Esperanza.
Understand.
I did the whole interview for an hour.
And you said,
No, I did
I
an
don't
interview.
want it. No, you said, I don't want Esperanza court. Did you not say, well, counsel,
Judges,
I will tell you this. There's a motion to revoke that's been filed. I'll hear the motion to revoke and everybody can present whatever evidence they wish to present.
Your Honor, if she does not meet criteria, then she will not be able to do the program as well. And that's what we believe, is that she does not meet criteria for the
No,
program.
she said, my understanding is, and this is from probation, that she did not want to be in Esperanza court. So this is what we're going to do. We are going to have a hearing on the motion to revoke. Everybody can present whatever evidence they want to present, and then the court will make a decision on whether or not to revoke her or whether or not to continue her. And Mr. Munoz, I'll give you time because I know you've been appointed to the case. So I will give you time. We can set it for a contested hearing. And if it's not contested, then it's not contested.
Correct, Judge.
And if you want to bring people from Esperanza court to come over on her behalf, I'm willing to hear it.
How much time is the court thinking about resetting it to?
How much time are you requesting? Of course, a minimum 10 days, but how much time are you requesting?
2 to 3 weeks, Your Honor.
All right, Ms. Ferguson, on this case, can you recall it in 3 weeks, please, for a contested? All right, September 12th, counsel?
Yes, Your Honor, that will work. And I imagine that the CLO has a copy of the motion to revoke for me.
Yes.
Thank you, Your Honor.
All right, thank you. So we'll be back on September 12th for a contested.
Now we reach the final hearing, and this is where everything comes together. The court has several possible paths: prison, Esperanza court, or deferred adjudication. You can tell Judge Boyd is carefully considering every part of the situation, not just the charges, but also the defendant's history, her behavior, and whether she actually seems willing to make changes. At first, it's easy to focus on the frustration of seeing someone return to court again, but as the hearing continues, you can also see that there may be a genuine desire to improve. The difficult part for any judge is finding that balance between giving someone another opportunity and making sure the community remains safe. I want to hear from you. You think she deserve another chance? Or should the court have moved straight toward prison?
Good morning. Good morning. Ms. Abrams, so where are we on this case?
So Judge, Mr. Munoz has done a wonderful job coordinating
And
with
I
the
smile at that because I knew you were going to say that. He always
He always
does.
says, right?
Thank you.
I'm coordinating with the PICU unit, and I made a couple of phone calls to Crosspoint, and they have accepted, approved, ready to go with Miss Morgan if the court allows. She has been approved for housing with them. They have agreed to ensure that she is on her medications, and in conjunction with the Center for Healthcare Services. I would ask that we put her on the mental health unit to be supervised with probation, and so forth. She was not eligible for Esperanza Court. She was not eligible for drug court. And I think at this point, this is the best place for her.
All right, State.
Judge, my understanding is that she was accepted into Esperanza Court. I think this may be the next best option that we have available.
So are you all withdrawing the motion and altering, amending conditions?
Yes, Judge.
All right.
No,
So is this what you want?
Yes, ma'am. I wanted you to do better, Your Honor, and be a productive member of society. I wanted to say to you, I owe you an apology. I was angry. July 16th was a hard day for me. I have been through a lot of trauma in my life, but I know I don't want to die in prison or go back to the prison. I want to do the best I can to be successful in life. I still have children. I have a 13-year-old, 24-year-old, 27-year-old grandchildren. And I owe you an apology for getting angry and saying I was angry, and I've been wanting to take anger management, and I'm going to take anger management and comply with all orders of probation department and the orders that you've written.
All right, well, apology accepted. And this is what people don't understand, and it's a hard thing to do. And, you know, I'm constantly growing. Nobody's perfect. Everybody's constantly growing. And I will tell you what I've learned to do, and I have to constantly remind myself to do it. If I see an email and I'm upset by the email, I don't respond to it right away. I'll respond to it the next day. And so that's what you should probably practice, responding the next day, because then you can perhaps take a step back and look at things objectively. That's my 2 cents.
Yes, ma'am.
That's a
Well,
really good
actually, not my 2 cents. That's at least $1.
That's a really good tip. Yeah.
It's hard to do, but if you do it, you'll find out that it's better for you. Because once you said something, you can't take it back. And there's never been a regret, I don't believe, where you regret that you didn't send an email right away, you know? All right. So I'll do the referral to Crosspoint. I'll agree with that. We're alternate amend conditions. If you'll file the motion to withdraw.
Yes, Judge.
So we'll alternate amend conditions to include Crosspoint, anger management, referral for Center for Healthcare Services,
And mental health unit.
and mental health unit.
Yes, ma'am.
All right. So in this court, people will say that probation is difficult, but I put conditions in place because I'm hoping those conditions that I put in place are something that will help you be successful. So in this court, to be successful on probation, communication is key. Your attorney will tell you this. If you have an issue, let probation know. If you think you're going to use, let probation know. I normally don't revoke people for seeking out help from probation. Like, I'm going to use probation, help me. Because we're here to hopefully make you a success.
Yes, ma'am. Your Honor.
All right. Is there anything else? All right. Good luck.
Looking back at the entire hearing, this was definitely a difficult decision. The court has already given her opportunities, and now the question becomes whether another chance will actually lead to change. Judge Boyd showed a lot of patience throughout this process, but patience only goes so far when the same problems continue happening. At the end of the day, programs like this only work if someone is willing to fully participate and take responsibility. A second chance can be powerful, but it also comes with expectations. The hope is that this becomes the moment where she finally decides to take the situation seriously and make a different choice moving forward. What do you guys think? Did the court handle this the right way, or should the outcome have been different? Thanks so much for watching. Don't forget to like and subscribe for more courtroom breakdowns. I really appreciate all the support, and I'll see you in the next one.